Hello friends, welcome to our academy. This is me, Dr. Sidharth Arora. Friends, welcome to part 2 of this series जो मैंने तुम्हारे लिए start की है. This is a series which is referring to Bear Act. Bear Act मतलब जिस act को हम लोग पढ़ रहे हैं, which is the Constitution of India. And in this Bear Act, I have intended, or this is my intention, that हम लोग will divide it into 4 parts. And 1 to 100, 101 to 200, 201 to 300, and so on and so forth. The plan here is all the important articles of this constitution I'll call out और मैं तुम्हें उसको explain कर दूंगा so that you are never going to get confused with the Constitution of India. One thing all of you must wrap your head around कि actually the source of polity, governance, IR, name it, IR चलो not the entire thing, but at least polity, governance, etc. will come only and only from the Constitution of India. And UPSC का trend change हो चुका है. You will see many previous year questions which are coming directly from the Constitution of India. Now there is a problem underlying this. इतना easy होता तो क्या चाहिए था? This is something that everybody understands, but it becomes very difficult for you to appreciate. Since Constitution of India, the supreme law of the land, the language is very complicated, at least for those guys who do not come from a legal background, in the sense they are not lawyers, they are not preparing for judicial services, and so on and so forth. तो उनके लिए करीब करीब practically impossible हो जाता है for them to understand what are they writing in the constitution. At least the nuances of the constitution you cannot understand. Worry not, I'll do that. In this series, I'll explain it to you. अब तुमको ये सब कुछ समझ में आ जाएगा. So, get ready and don't miss even one single session for all of this. This will come really be very useful for all of you. इससे पहले कि हम start करें, this is the great offer by an academy, flat 60% off, which implies that 15 month का कोर्स तुम्हें 23,499 रुपीज में मिल जाएगा. 18 month का कोर्स तुम्हें 24,999 में मिल जाएगा. You will get the best of the best educators from all over India on one platform. Please remember, date mark कर लो. The offer पहले खत्म हो गया था, but now the offer has been extended till 28th of February. All you have to remember, and you must remember, is my code SIDLIVE, SIDLIVE. ये मेरा रेफरल कोड है, मेक श्योर दैट यू यूटिलाइज इट. एक और बहुत इंपॉर्टेंट रिमाइंडर है, एंड यू मस्ट मार्क योर कैलेंडर, एंड दैट इज 1st of March 7 PM to 9 PM. This is the most epic educational festival for IIT, JEE, NEET, UG and Foundation. So this is a big event. All of you must be a part of it. So calendar mark कर लेना, 1st of March 7 PM to 9 PM. This is the context. Now plan ये है, this is the plan that we will divide the entire Constitution of India into 4 different parts and then just do all the important constitutional articles one by one. Having said so, ऐसा नहीं है कि मैं तुम्हें से पढ़ाता चले जाऊंगा without considering or without even thinking कि तुम लोगों ने इसको रिवाइज किया कि नहीं. Sorry, that's not my way of working. So let's first have a small recap of test. तो मैं part 2 पढ़ लूंगा. Okay, I will teach you 101 to 200 today. But before that, right, I will take a test. Are we ready? If you're ready, so from all the previous part जो भी मैंने पढ़ाया है अभी तक, we will have a small test so that मुझे ये आइडिया हो जाए कि you are taking this series seriously. And उसके बिना ऐसे भी क्या फायदा है ना, if you're just running from one video to another video, से फायदा क्या होने वाला है? So you're not going to learn anything. Make sure that you are a part of it. So MCQs के फॉर्म में करते हैं. Right? Let's take the first question. 60 seconds. Which article of the Constitution deals with the Citizenship Act of 1955? So it is not Citizenship Act of 1955, but कुछ ना कुछ उसके dealing है. Right? Which article of the Constitution? Hurry up. You have 60 seconds to answer. 40 seconds. About 20 seconds. Last 10 seconds. Not in my wildest thought process, मैंने तुम्हें यह पूछने की कोशिश नहीं की थी कि सिटीजनशिप एक्ट 1955 क्या है. I was asking which of these articles of the Constitution deals with Citizenship Act 1945. So the answer, of course, is Article 11, which gives the Parliament to make a law related to citizenship after 26 January 1950. Go back, watch this. Watch part 1 of the series. I've done this in considerable detail. एक बार पढ़ लेना. Let's go for another question. Which article of the Constitution deals with the phrase India, that is Bharat, shall be a union of states? Quickly answer. Forty seconds. India, that is Bharat, shall be a union of states. Familiar phrase. Where is it written? Approaching the end. Quickly. And the answer, I hope some fatafat answer there. For those who are missing it, please watch the first part. Answer, of course, is A. Article 1. India, that is Bharat, shall be a union of states. This is something that we have done in advance. This could have been easily guessed also. Let's look at the next question. 60 seconds start. Which article of the Constitution deals with life and personal liberty? Which article of the Constitution deals with life and personal liberty here? I think this is amongst the easiest question that you may like to answer. ऐसा आंसर बोनस होता है in case it comes in the exam. Great. About 15 more seconds to go. Quickly. So, Article 21 of the Constitution, I am sure no person shall be deprived of his life or personal liberty except according to procedure established by law. I said this is the simplest one. Having said that, दुनिया में ऐसा कोई क्वेश्चन नहीं है जिसको हम सिंपल या डिफिकल्ट बोल सकते हैं. You know it, you know it, you don't know it, you don't know it. Let's look at another one. Hurry up. Which article of the Constitution deals with the quorum in the Parliament? All of these I have already dealt with them in considerable detail in the last part. Those who have missed it, make sure that you watch part 1 of the series for explanations. 63, 100, 52, 37. Which article of the Constitution? Let's be very, very clear on all of these questions before we go ahead. Hurry up. 20 seconds to go. Quickly. Those who missed it, worry not. Part 1 is available on YouTube. Might as well just go there, revise. Considerable detail may I've done this. Answer, of course, is B. Article 100 of the Constitution will deals with quorum. Quorum is the minimum attendance that is required in both Lok Sabha and Rajya Sabha before any meaningful matter can be solved in case of the Parliament. Let's go with another one of this. Which article of the Constitution deals with the office of the President? President. Hurry up. Off पे mark. Quickly. Last time मैंने आप लोगों को एक shortcut भी दिया था. I don't know whether you remember that or not. Which article of the Constitution deals with the office of the President? Quickly. Last 10 seconds. The time is up. Let's have the answer. The answer, of course, is Article 52 of the Constitution. 52 deals with there shall be a President of India. That's it. Full stop. Nothing else. Article 52 of the Constitution. Moving on. Which article of the Constitution deals with the office of the Vice President? ABCD 63, 100, 52, 37. Forty seconds. For those who have missed it, focus on the part that is written in red. Watch part 1 of the series for all the explanations. Considerable detail में more than 1 hour 15 minutes का video है. Make sure that you watch them. उसके बाद article should be the least of your headache. Answer of course is Article 63 of the Constitution. Answer of course is A. There shall be a Vice President of India. That is Article 63 of the Constitution. Let's look at another one. Which article of the Constitution deals with non-justiciability of DPSPs? Now, this is kind of tricky. If you know it, you know it. You don't know it, go for it. 40 seconds. Quickly, half a mark. Non-justiciability. Now, I'm not going to describe, I'm not going to spend even a second explaining the question. You must know this. Non-justiciability of DPSP. 10 seconds to go. Time is up, and the answer, of course, is Article 37. The principles which are mentioned in this part are not directly enforceable by the court of law. Still, nevertheless, they are fundamental to the governance of the country, and it shall be the duty of the state to follow these principles in making laws. Article 37. No ifs and buts about it. Let's look at the next question. Which article of the Constitution deals with impeachment of the president? A, B, C, D, 61, 60, 51, 50. Forty seconds. Twenty seconds to go. And the time is up. The word impeachment in the Constitution is written only, and I repeat, only in Article 61 of the Constitution. Nowhere in the Constitution, apart from Article 61, would you find the word impeachment. One could argue कि impeachment word और बहुत जगह use होता है, but sorry, technically speaking, it is only in the Constitution of India. Next question. Which article of the Constitution deals with the oath of the President? 61, 60, 51, 50. All of these, मैं कोई भी नया क्वेश्चन नहीं पूछ रहा हूं. All of these have been discussed in the previous part. तो मैं कुछ भी अनोखा नहीं पूछ रहा हूं. Which article of the Constitution? Oath of the President. Go for it. The last 10 seconds to go. And the answer, Article 60 of the Constitution. Answer, of course, is B. I shall protect, preserve, and defend the Constitution of India. The President is administered oath by the Chief Justice of India. or in his absence, the next senior most judge of the Supreme Court, he says, I will protect, preserve, and defend the Constitution of India. Amazing question, amazing answer. Go for it. Next question. Which article of the Constitution deals with the aim of maintaining a just international order? So I've just taken out couple of lines from that entire article. Okay, तुमको सिर्फ hint होना चाहिए and you must be able to answer that question. Which article of the Constitution deals with the aim of maintaining a just international order? Go for it. Half a mark. Last 10 seconds to go. Quickly. I think it समझ में आ जाएगा. You could have very easily eliminated also. In fact, if you recall, this has been an asked question in the previous UPSC examination. Article 51, India shall maintain international, peace and order. We shall trust or we shall maintain the trust on all treaties, obligations, and settle international disputes by arbitration. Answer, of course, is C. Let's look at the next one. Moving on. Which article of the Constitution deals with the aim of separating judiciary from the executive? 61, 60, 51, 50. I think this would become the simplest question to answer since all of them can be easily done by elimination. Use your brain. Which article of the Constitution separation of judiciary from the executive? Half a mark. Last 10 seconds ago, I think this is a very popular. I mean, I don't know how to describe the word popular, but this is a very often asked question, and the answer, of course, is the Article 50. That the state shall endeavor to separate judiciary from the executive from the public services of the state. This is Article 50. I hope you have scored amazingly well in this test. अगर तुम्हारा सारे करेक्ट आ गए, congratulations, you done an amazing job. अगर कम आ रहे हैं, worry not, revision is the time. This is the time to revise. And जिनको बिल्कुल नहीं आता, please look at the part 1 of the series and I'm sure you are going to be understanding the articles like never before. This is part 1 completed. अब मैं इसको बोलूंगा part 1 completed because first you are revised, first you studied, then you revised, you tested yourself. इसको बोलते पढ़ाई करना. जस्ट पढ़ने से कुछ होने वाला है नहीं. सो नाउ मूविंग ऑन, हम लोग आर्टिकल 101 से लेकर आर्टिकल 200 वी डिवाइडेड द कॉन्स्टिट्यूशन इनटू 4 पार्ट्स. दिस इज द सेकंड पार्ट. अब इसमें से कुछ चोजन आर्टिकल्स आई विल डू इन डिटेल विद ऑल ऑफ यू. बड़े ध्यान से मेक श्योर दैट यू टेक नोट्स ऑफ दिस, अंडरस्टैंड एवरी वर्ड. ओके, और अगर कोई फिर भी डाउट आएगा, आई विल बी हैप्पी टू टेक अ स्पेशल क्लास फॉर दिस, और उसमें तुम आओ और तुम अपना डिटेल्स में मुझे डाउट्स पूछ सकते हो. लेट्स लुक एट द फर्स्ट वन. सो सेकेंड पार्ट में जो आज का पहला पार्ट है इस आर्टिकल 102 ऑफ द कॉन्स्टिट्यूशन. तो कीप योर आई ऑन द बोर्ड ताकि तुम्हें इजी वर्ड्स भी मिल जाए. राइट, एंड द रेस्ट ऑफ द पॉइंट्स मैं तुम्हें समझाता चले जाता हूं. सो आर्टिकल 102 ऑफ द कॉन्स्टिट्यूशन gives you certain, please pay close attention, member of parliament बनने के लिए, legislator बनने के लिए, you have to contest elections. There's no surprise in that. लेकिन do you also realize कि member of parliament बन रहे, legislator बन रहे, there are bound to be certain qualifications and there are bound to be certain disqualifications. Qualifications आपको मालूम है, लोकसभा के लिए you have to be a citizen of India, you have to be 25 years of age, and so on and so forth. Rajya Sabha में 30 years of age and citizen of India. लेकिन the same constitution also provides कि there could be certain disqualifications. which will not allow, despite the fact, notwithstanding the fact कि हो सकता है तुम इलेक्शन जीत भी जाओ, that's a different issue, but we will not let you become a member of parliament, and this is given under article 102. Now I'll just help you out before we move ahead. एक रूल ऑफ 89 याद रखो. What is rule of 89? So article 102 add 89, it will become article 191. In other words, if 102 is providing the grounds of disqualifications of members of parliament, then 191 will provide the grounds for disqualifications of members of state legislature, Vidhan Sabha and Vidhan Parishad, right? So 102 and 80, and this rule of 89 can be applied practically in 9 out of 10 cases where X is an article related to the union, and add 89 to it. Whatever is the number that you arrive at would be the article related to states. Take an example. So suppose I say article 74 of the constitution deals with union council of ministers to be headed by the prime minister. Add 89, the sum that we arrive at is 163. That would be the state council of ministers to be headed by the chief minister. Let's take another example. So article 111 of the constitution will give you the so-called veto powers to the president. Then add 89, article 200 will give the veto powers to the governor, and so on and so forth. 79 will speak about the parliament, plus 89, 168 will talk about state legislature. I hope you get the idea. You can draw parallel between most of these articles between the union and the state. Necessarily not always true. Take it with a rule of thumb. There are a couple of exceptions, but in most cases they will serve you well. Let's look at article 102. So now there are certain grounds for disqualification. So क्या है disqualification? Number one, अगर there is a member of parliament who is either a member of parliament sitting or he wants to contest, but he is occupying office of profit. Everyone write the word office of profit under the government of India or the government of the state. भाई हम तुमको member of parliament नहीं बनने देंगे. Number two, अगर कोई कॉम्पिटेंट कोर्ट, अगर किसी अदालत में प्रोसेस में, कोर्ट प्रोसेस में यह सिद्ध हो जाए, दिस इज प्रूवन, दिस इज हेल्ड बाय कॉम्पिटेंट कोर्ट कि वो अनसाउंड माइंड के है, इज नॉट मानसिक रूप से ठीक, देन सॉरी, वी आर नॉट गोइंग टू अलाउ यू टू बी अ मेंबर ऑफ पार्लियामेंट. अगर मुझे ये पता चल जाए, आई गेट टू नो दैट ही इज एन अनडिस्चार्ज इंसॉल्वेंट, ये बैंकरप्ट हो चुके हैं, ऑलराइट, और वो अभी तक पूरा, उन्होंने जो कर्जा है वो पूरा नहीं किया हुआ है, अनडिस्चार्ज इंसॉल्वेंट है, दिवालिया घोषित हो चुके हैं और उन्होंने अपना कर्जा अभी तक अदा नहीं किया, अनडिस्चार्ज इंसॉल्वेंट है, देन सॉरी गाइस, वी आर नॉट गोइंग टू लेट यू बी अ मेंबर ऑफ पार्लियामेंट. दिस इज नंबर 3. नंबर 4, बाय हिज ओन चॉइस ही हैज डिसाइडेड कि ही विल नो लॉन्गर बी अ सिटीजन ऑफ इंडिया. भाई मैं छोड़ के जा रहा हूं अपनी सिटीजनशिप, सॉरी ब्रदर, यू वोंट बी अ पार्ट ऑफ, बी अ मेंबर ऑफ पार्लियामेंट. Also कि कोई लॉ मेड बाय द पार्लियामेंट, एनी लॉ मेड बाय द पार्लियामेंट के अंतर्गत यू आर डिस्क्वालिफाइड. वन ऑफ द लॉज इज रिप्रेजेंटेशन ऑफ पीपल्स एक्ट ऑफ 1951. अंडर रिप्रेजेंटेशन ऑफ पीपल्स एक्ट ऑफ 1951 अगर आपने ऐसा कुछ किया है, विच इन मोस्ट केसेस करप्ट प्रैक्टिसेस सेक्शन 123, either ways, if you are disqualified, sorry bro, you are not going to be a member of parliament. And last but not the least, if 102 subclause 2. So this is all of 102 subclause 1, A, B, C, D, E. Then there is 102 subclause 2, which was of course added later on in the day by the 52nd Constitutional Amendment Act 1985. 52nd Constitutional Amendment Act 1985 में 10th schedule डाला गया था, the anti-defection law, which says that if you are held guilty under anti-defection law, Article 102 subclause 2 says you shall not be allowed to be a member of parliament. So now look at the board. I am sure that you will understand this far better. Okay. Now look at the board. So a person is disqualified. Number one, मैंने जैसे बोला, if you are holding office of profit either under the government of India or the government of the state. Second, you are declared of a person of unsound mind by a competent court. You are an undischarged insolvent. You are not a citizen of India because you by yourself acquired a voluntarily you have acquired a foreign citizenship. you're disqualified by any law made by the parliament. And finally 102 subclause 2 जो 10th शेड्यूल की बात है, which was of course added by the 52nd Constitutional Amendment Act of 1985. I am sure कि तुम इसको भूलोगे नहीं, तो 102 1 A B C D E कर देना, 102 subclause 2. Add 89 will take you to 191, which is disqualification of the member of state legislature. Please remember, this applies to both who are sitting or who want to contest an election for the parliament. Clear, simple. In fact, एक ही झटके इसमें हमने 2 आर्टिकल्स कर लिए, although we've done just one. So let's look at the next one. So the next is 105. So पहले बोर्ड पे देख लो and start taking notes of it. It says powers, privilege, etc. of the houses of the parliament and of the members and committees thereof. So this is dealing with privileges, विशेष अधिकार, right? So let me explain this to you. So 105, can we do the mathematics again? 89. So 105 will deal with the privileges, the Vishesh Adhikar enjoyed by the members of parliament. Add 89, you will arrive at 194 of the constitution. 194 will deal with the special Adhikar or the special privileges or the Vishesh Adhikar of the members of state legislature. Now, before we understand all of this and before we deep dive into it, let's understand and get this point. So to illustrate my point, let me explain this to you. We all have freedom of speech and expression. I hope all of you agree, right? So Article 19 subclause 1 subclause A में हम सबके पास freedom of speech and expression है. Fair enough. Then, so freedom of speech and expression में there are reasonable grounds of restriction. 19 subclause 2 बोल रहा है कि आप ना freedom of speech and expression use करो, लेकिन don't violate the sovereignty, security, integrity of India. Don't go against public order, public peace. Don't go against decency and morality. Don't do contempt of court. Don't do defamation. Don't do incitement of offense. Don't destroy India's relationship, or rather bring down India's relationship, which are friendly relationship with foreign states. ये क्या है? ये restrictions है. ये reasonable grounds of restrictions है on my freedom of speech and expression. Now, why my? It's most of you also. Citizens के, right? हमारे freedom of speech and हमारे fundamental rights, कुछ fundamental rights पर restrictions है. Right, reasonable grounds of restriction. Now, थोड़ी देर के लिए, okay, picture this. Go to the Parliament House. अब मैं Parliament House में, I am a member of Parliament. Now, if I go to member as a member of Parliament, मुझे बहुत कुछ बोलना है, मुझे अपने विचार व्यक्त करने हैं. You know, there are many things that I have to say. Now, interestingly, the members of Parliament on the floor of the house के अंदर, सदन के अंदर practically enjoy, it's practically in the sense because उसमें भी है थोड़े restriction, but practically enjoy infinite amount of freedom of speech and expression. वो कुछ भी बोल सकते हैं practically. बहुत रेयर केसेस में उनको रोका जाएगा, और वो भी जो रोका जाएगा ना, वो कोर्ट ऑफ लॉ नहीं रोकेगा, वो पार्लियामेंट खुद रोकेगा. Now you may be surprised, one may argue ये क्या बात हुई, this is not good. राइट, इनको क्यों स्पेशल प्रिविलेजेस मिलता है, इनको क्यों विशेष अधिकार मिलता है? तो द पार्लियामेंटेरियंस आर्ग्यू दैट वी नीड दिस, हमें ये विशेष अधिकारों की जरूरत है, सिंस इट हेल्प्स अस परफॉर्म ड्यूटीज एज पार्लियामेंटेरियंस. तो ऐसे बहुत सारे विशेष अधिकार है, राइट. द विशेष अधिकार कुड ऑल्सो बी कि फॉर एग्जाम्पल पार्लियामेंट एज अ होल, वो बोल सकते हैं कि हम लोग है ना किसी को विजिटर को आने ही नहीं देंगे, कोई जर्नलिस्ट नहीं आएगा. टुडे वी विल परफॉर्म ऑल द ड्यूटीज, ऑल द डिबेट, डिस्कशंस एक्सेट्रा इन कैमरा. उसको बोलते हैं इन कैमरा, सीक्रेट मीटिंग कर सकते हैं. वी कैन एक्सक्लूड स्ट्रेंजर्स, इसको बोला जाता है एक्सक्लूड स्ट्रेंजर्स. हम ये भी बोल सकते हैं द पार्लियामेंट कैन टुमारो टेक आउट एन ऑर्डर एंड सेड कि ये जो अभी हम लोग जो भी हो रहा है इसको कोई पब्लिश नहीं करेगा, या जो हमने वर्ड को मार्क कर दिया है, एक्सपंज कर दिया है, ये कल के मीडिया में नहीं आएगा. मेनी टाइम्स यू मस्ट हैव हर्ड कि कभी कभी बोलते हैं एक्सपंज कर दिया गया, वो वर्ड हटा दिया गया. तो इवन व्हेन दे आर स्पीकिंग, अगर आपको मीडिया में दिखा देता तो बीप बच जाता है कि वो वर्ड हम लोग मना कर रहे. ऑल्सो देयर इज फ्रीडम फ्रॉम अरेस्ट, सिविल अरेस्ट में -40 ड्यूरिंग सेशन +40. इन अदर वर्ड, सेशन स्टार्ट होने से पहले 40 दिन, ड्यूरिंग द पीरियड ऑफ द सेशन, एंड +40 उसके बाद सिविल अरेस्ट से तुम्हें सेफ्टी है इफ यू आर अ मेंबर ऑफ पार्लियामेंट. ये कहां लिखा हुआ है? ये सब लिखे or rather it emerges from Article 105 of the Constitution. Now there is an interesting part here also. The interesting part here is कि इसका कोई लॉ नहीं बना हुआ. These are practically indefinite number. Whatever the parliament wants to form as a विशेष अधिकार, as special privileges, वो अपने लिए बना सकते हैं. इस पे एक बहुत अच्छा क्वेश्चन आता है कि जो पार्लियामेंट्री प्रिविलेजेस है दे आर अनकोडिफाइड एज अपोज टू सुप्रीम कोर्ट एंड हाई कोर्ट के पास भी कंटेम्प्ट ऑफ कोर्ट की पावर्स है, विच विल कम टुडे, विल लेटर इन द डे विल डू दिस. ओके, सो उनके पास भी कंटेम्प्ट ऑफ कोर्ट की पावर्स है, बट दोज आर कोडिफाइड इन द सेंस दैट दे कम फ्रॉम और दे इमर्ज फ्रॉम अ लॉ विच इज कॉल्ड एज कंटेम्प्ट ऑफ कोर्ट एक्ट ऑफ 1971, नॉट फॉर पार्लियामेंट. Parliament will enjoy practically indefinite number of privileges because it is uncodified. This is also a very debatable issue, but that's not the purpose of the day today. So let's look at next one. Next is 108. 108 पहले लिख लो, joint sitting of both houses in certain cases. So मैं सब कुछ explain करता हुआ जाऊंगा, but you'll do well to write it down. पहले लिख लो. All right. So, first understand a fundamental formula in case of parliament. Parliament is the supreme legislative body of India. सबसे बड़ा जो कानून बनाने का, विधि बनाने की जगह है वो पार्लियामेंट है. Parliament has got two houses, लोकसभा and the Rajya Sabha. Right? लोकसभा the lower house, Rajya Sabha the upper house. Now that's not the issue. If you remember from the previous सेशन हमने किया था, आर्टिकल 79 ऑफ द कॉन्स्टिट्यूशन says पार्लियामेंट कंसिस्ट ऑफ लोकसभा, द राज्यसभा एंड द प्रेसिडेंट ऑफ इंडिया. नाउ वन में आस्क, वन में वंडर, प्रेसिडेंट, हाउ कम प्रेसिडेंट? प्रेसिडेंट इज नॉट अ मेंबर ऑफ द पार्लियामेंट. एब्सोल्युटली अग्रीड. पार्लियामेंट मेंबर, प्रेसिडेंट इज नॉट अ मेंबर ऑफ द पार्लियामेंट, बट प्रेसिडेंट इज अ फंक्शनल पार्ट ऑफ द पार्लियामेंट. हाउ डू आई एक्सप्लेन दिस? मैं इसको एक्सप्लेन कैसे करूं? सो पॉइंट यहां पर है कि पार्लियामेंट का काम होता है बिल को लॉ में कन्वर्ट करना, बिल को कानून में कन्वर्ट करना. फॉर एनी बिल टू बिकम अ लॉ, किसी भी बिल को लॉ में कन्वर्ट करने के लिए इट हैज टू बी, एंड आई रिपीट दिस लाइन, डोंट टेक इट फॉर द टाइम बीइंग, डोंट डिबेट इट, टेक इट ऑन फेस वैल्यू. इट हैज टू बी पास बाय लोकसभा, हैज टू बी पास बाय द राज्यसभा, हैज टू रिसीव द असेंट. किसी किसी के माइंड में ये बात आ रही होगी, मनी बिल, राज्यसभा का रोल फॉर्मल है. आई नेवर सेड मैंडेटरी रोल की फॉर्मल रोल. मैंने बोला पास होना चाहिए. पास होना है लोकसभा, पास होना है राज्यसभा, पास एंड देन असेंटेड बाय द प्रेसिडेंट. देन एंड ओनली देन द बिल शैल बिकम अ लॉ. नाउ लेट्स पिक्चर अ कंडीशन कि लोकसभा एंड राज्यसभा के इक्वल पावर्स है. लेट्स consider a picture, or let's picture this, get a canvas here, कि एक हाउस ने पास कर दिया, पे क्लोज अटेंशन, एक हाउस ने पास कर दिया लेकिन दूसरे ने रिजेक्ट कर दिया. कंडीशन नंबर 1. नंबर 2, एक हाउस ने पास कर दिया, सेकेंड हाउस ने सर्टेन चेंजेस सजेस्ट करने के लिए उस बिल को फर्स्ट हाउस के पास वापस भेज दिया, लेकिन फर्स्ट हाउस अपनी जिद पे रहा और बोला नो, वी आर नॉट एक्सेप्टिंग योर suggestions. Condition number 2. Condition number 3, फर्स्ट हाउस ने पास कर दिया और सेकेंड हाउस ना उसको पास कर रहा है ना उसको वापस भेज रहा है, अपने पास 6 महीना संभाल के रख रहा है. इन अदर वर्ड्स विदहोल्ड कर रहा है. कैन वी रिपीट दिस क्विकली? तो मैंने क्या बोला? देयर आर 3 पॉसिबल कंडीशन. फर्स्ट हाउस पासेस इट, सेकेंड हाउस रिजेक्ट्स इट. फर्स्ट हाउस passes it, second house sends back with recommendations to which the first house does not agree. Number 3, first house passes it, second house holds it, withholds it for a period of at least 6 months or more. ऐसी कंडीशन को बोला जाता है deadlock. In the constitutional scheme that we have, every bill requires to be passed by the Lok Sabha, the Rajya Sabha and assented by the President. But what to do now? We are in a fix now because one house and the second house are not agreeing. So it will never go to the President and the President won't give assent. The President won't get assent. The bill shall not become into a law. इस कंडीशन को डेडलॉक बोला जाता है. क्या बोला जाता है? डेडलॉक. So technically it is a deadlock. नाउ इट इज इन सम केसेस rejected. यार नहीं हो रहा, what can we do about it, right? But in certain conditions, it is possible that the government may feel that we need such a law. हमें इस law की आवश्यकता है. In such cases, the Prime Minister will advise the President. I'm telling you, Prime Minister will advise the President. And the Prime Minister will advise the President, Mr. President, please call a joint sitting of the both houses of the parliament. तो लोकसभा और राज्यसभा को बोला जाएगा कि साथ में आ जाओ, राइट? सिट टुगेदर, लेट्स हडल टुगेदर, लेट्स इंट्रोड्यूस द बिल अगेन. जो भी डिबेटेबल इशू है, या तो पूरा बिल में गड़बड़ है, हमारी तुम्हारी अग्रीमेंट नहीं हो रहा है, या फिर वो पार्ट जहां पर हमारा मतभेद हो रहा है, लेट्स डिस्कस दिस, डिबेट इट एंड वोट अगेन. इस तरह से हो सकता है वी मे बी एबल टू रिजॉल्व द डेडलॉक. और अगर ये डेडलॉक रिजॉल्व हो गया, देन वी सेंड इट टू द प्रेसिडेंट शैल साइन इट एंड गेम इज ओवर, बिल बिकम्स अ लॉ. इसको बोलते हैं अटेम्प्ट टू ब्रेक अ डेडलॉक. जॉइंट सिटिंग रेयर होता है. इनफैक्ट पोस्ट इंडिपेंडेंट इंडिया में ओनली थ्री टाइम्स, द डाउरी प्रोहिबिशन, द बैंकिंग सर्विस एंड द पोटा विच इज 2002 का लॉ, केवल 3 बार ज्वाइंट सेशन ऑफ द पार्लियामेंट बुलाकर डेडलॉक ब्रेक करके लॉ बनाया गया. बिकॉज में राज्यसभा का जो इंफ्लुएंस होता है ना, वो कम हो जाता है. बिकॉज राज्यसभा इज हाफ द स्ट्रेंथ ऑफ लोकसभा. तो लोकसभा डोमिनेट कर जाती है. दैट इज वाई राज्यसभा डज नॉट लाइक इट. एंड राज्यसभा रिप्रेजेंट्स फेडरलिज्म, सो काइंड ऑफ इट इज अ काइंड ऑफ शेड ऑफ ग्रे टू वायोलेटिंग फेडरलिज्म. तो इसको आमतौर पे डिस्करेज किया जाता है. हैविंग सेड सो, Article 108 deals with joint session. Now, there's a warning here. I must warn you at this stage. So it's a very clear part. Don't do rule of 89 here. We have already discussed. X plus 89 is state, right? So don't do 108 plus 89. Why not? One may ask. Because there is no parallel to be drawn from 108 and juxtaposed on a state condition. In other words, state mein there is no joint session. So even if there is a Vidhan Sabha and Vidhan Parishad, which not all the states have, तो भी अगर वहां पर disagreement हो गया, there is completely different scenarios going on. It has got nothing to do with joint session. Joint session of the houses state level पर नहीं होते. Very important googly question that is possible for you. Now you'll do well if you read 110 from the board in detail. So quickly read ek karke, right? Go through the entire part. Definition of money bills. A money bill is defined as one that solely addresses. अभी ये मैंने simplify किया. This is not the exact language. Okay, I've simplified for it. धन विधेयक. Let me explain this to you. So many a times, अब तो recently we had a union budget. Union budget is a classical example of a money bill. कभी कभी ये क्वेश्चन आ जाता है. तो अभी I discussed something that every bill needs to be passed by the Lok Sabha, the Rajya Sabha and assented by the President. Money bill is a sui generis, it's one of its kind. कैसे होता है? Money bill has to be introduced in the Lok Sabha. Money bill once passed by the Lok Sabha will be sent to the Rajya Sabha. तो यहां पे ऐसा नहीं है. Ordinary bills जो होते हैं वो लोकसभा या राज्यसभा कहीं भी इंट्रोड्यूस हो सकता है. एंड द सेकंड हाउस कुड भी राज्यसभा एंड लोकसभा एज द केस में भी. लेकिन मनी बिल में पहला हाउस हमेशा लोकसभा होगा. लोकसभा विल पास द बिल. वंस लोकसभा passes the bill, it will be sent to the राज्यसभा. Now, here is the difference. राज्यसभा का रोल इन केस ऑफ मनी बिल एक औपचारिकता होती है. इट इज अ फॉर्मल रोल. व्हाट डज दैट मीन? राज्यसभा विल बी अफोर्डेड ओनली 14 days. राज्यसभा विल बी टोल्ड, guys, you have 14 days. Either you pass the bill or you send the bill back with recommendation. You send the bill to the Lok Sabha with certain recommendation. But make no mistake about it, those recommendations are not bound, or the Lok Sabha is not bound to accept those recommendations. Number 3, you may choose to withhold that bill. Okay, मैं 14 दिन कुछ भी नहीं करते. Either ways, worry not. Why? Because Rajya Sabha has only a formal role in money bill. After 14 days, at the end of 14 days, the bill will be deemed to be passed. The word is deemed. Deemed मतलब समझा जाएगा कि पास हो गया. Now that makes it a very interesting concept. This is sometimes described in a very beautiful language. This is described as power of the purse. Okay, Lok Sabha has the power of the purse. Now, what is a very interesting thought? That Lok Sabha has got higher powers than Rajya Sabha. So, it's a compelling case. You can make an argument on this that Lok Sabha has equal powers to Rajya Sabha in practically everything else. But in Lok Sabha has got higher powers than Rajya Sabha in case of money bill. Now, that actually warrants that we must know what a money bill is. Now, this is very interesting. कि जी मनी बिल होता क्या है फिर तो इतना बड़ा पावर मिल गया तो व्हाट डू यू डू तो वेरी इंटरेस्टिंगली तुम्हें कहीं और नहीं जाना पड़ेगा यू हैव टू लुक नो फर्दर देन आर्टिकल 110 ऑफ द कॉन्स्टिट्यूशन हैव अ लुक तो 110 ऑफ द कॉन्स्टिट्यूशन में जो लिखा है ध्यान से सुनना जो लिखा है अगर ओनली जो 110 में लिखा है वही है उसके आगे एक एक्स्ट्रा वर्ड नहीं है देन इट इज अ मनी बिल सो व्हाट इज मनी बिल डीलिंग विद नाउ यू कैन लुक एट द बोर्ड मनी बिल डील्स विद imposition, abolition, regulation, remission, alteration of taxes. Okay, I hope you have written. So number one क्या है sir? Imposition, abolition, regulation, remission, alteration of taxes. Custody of the consolidated fund of India, custody of the contingency fund of India. Appropriation of funds out of the consolidated fund of India. Any expenditure or credit marked to the consolidated fund of India. Any debt or borrowing which is marked to the consolidated fund of India. Any receipt or any debit out of the consolidated fund of India. और अगर कोई ऐसा incidental matter जिसको गवर्नमेंट ने डिसाइड किया कि विल चार्ज इट टू द कंसोलिडेटेड फंड ऑफ इंडिया दिस इज मनी बिल नाउ वेरी इंटरेस्टिंगली द की वर्ड इज ओनली ओके सोलली ओनली सिर्फ इतने ही चीजों से डील करना चाहिए नथिंग एल्स शुड बी इन दैट मनी बिल इफ दैट बिल हैज ओनली the matters which are being dealt by in 110 then it is a money bill बहुत ही solid question है you must know this I like to emphasize this yet again 110 deals only with imposition abolition regulation remission alteration of taxes custody of the consolidated fund and the contingency fund appropriation out of funds from the consolidated fund of India any debt, any borrowing, any charge, any receipt to the consolidated fund of India. This is, or declaring of any expenditures which are marked to the consolidated fund of India. Full stop. That's it. Nothing else. This has to be money bill. बहुत ही solid question है. And since we've just crossed the day of the budget, right, I'm sure you must know this completely. So this is 110 and let's try and understand this part. Let's look at Article 111. Bada hi famous article. First, write this down. When a bill has been passed by both the houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. Please write this down. Very interesting. Isko likho pehle. First, write this down. Most of the aspirants ko exact terms aate nahi hai, and that is what becomes a major headache for them in the exam. आर्टिकल 111 ऑफ द कॉन्स्टिट्यूशन इज द वन जिसको आप लोग बहुत पुराने टाइम से इवन फ्रॉम द स्कूल डेज वी बीन रीडिंग अबाउट इट एज इफ इसको वर्ड यूज किया गया है वीटो वेरी इंटरेस्टिंगली वीटो नाम का पूरा वर्ड यहां पर नहीं लिखा हुआ है हैव अ लुक एट इट अगेन राइट यहां कहीं वीटो नहीं लिखा है ऑल इट सेज इज व्हेन अ बिल हैज बीन पास्ड बाय द हाउसेस ऑफ द पार्लियामेंट it shall be presented to the President and the President shall declare either that he assents to the bill or that he withholds his assent therefrom. Veto word is not mentioned in Article 111 of the Constitution. Okay, you might just like to open the PDF या अगर तुम्हारे पास book है तो might as well read it. So first understand, let's go back to Article 79. The Parliament consists of Lok Sabha, the Rajya Sabha and the President of India. Then I told you something, that for any bill to become a law, it must be passed by the Lok Sabha, then it must be passed by the Rajya Sabha, or it could be vice versa also, and then assented to by the president. Now let's take an example of now understanding Article 111 in practical terms. So assuming for the fact House number 1 passes it, House number 2 passes it, and House number 2, after House number 2 passes it, it is sent to the president. Now president के पास interestingly there is this power कि either he will assent to the bill, assent matlab he will accept it, sign it, the bill will become a law or an act. But the constitutional scheme also suggests that the president may choose not to assent. Now, this is very interesting. Now, on first look, prima facie, it sounds कि कैसा इसका मतलब है the president is rejecting the bill. No. Let's keep the terminology as mentioned in the constitution. It does not say president is rejecting the bill. It says the president is withholding the assent. Now, withholding and rejecting में जमीन आसमान का फर्क होता है. If you are able to appreciate कि India is a parliamentary democracy, and parliamentary democracy is based on the formula which is called as ERL, which I tell in the class very often. Executive is responsible to the legislature. Executive is answerable or accountable to the legislature. We have legislative supremacy. Executive supremacy नहीं है. Legislative supremacy. So let's assume House number 1, House number 2 has passed the bill, sent to the president, and the president rejects the bill. I'm just, for the sake of argument, let's do it. Is it possible? Certainly not possible, because it goes against the very spirit, the very sum and substance of executive and responsibility towards legislature. तो क्या किया एग्जीक्यूटिव ने लेजिस्लेचर का पूरा काम ही बर्बाद कर दिया. नॉट डन, इट्स नॉट पॉसिबल. लेकिन यहां लिखा हुआ द प्रेसिडेंट विल विदहोल्ड द असेंट. नाउ व्हाट डज दैट मीन? प्रेसिडेंट सेज फॉर द टाइम बीइंग आई एम नॉट गिविंग असेंट. फॉर द टाइम बीइंग I am withholding the assent. Now, what is this supposed to do? So now the bill will be sent back to the parliament. All right. So now the bill will be sent back to the parliament, which is very popularly described as suspensive veto. In a way, the president wants the parliament to reconsider the bill. एक और बार देखो जी, मुझे कुछ गड़बड़ लग रहा है. I am not very happy with this bill. So the parliament ka both the houses will undergo the entire process of passage of bill yet again. Again introduction, debate, discussion, voting. Again introduction, debate, discussion, voting in both the houses. It will repeat in both the houses. This sending back the bill to the parliament can be done only once. That means suspensive veto can be exercised only once. एक बार फिर से वो parliament does the entire process. And the parliament decides कि हाँ जी हमने reconsider भी कर लिया, we are very happy about it, and we are sending it back with or without changes to the president. Now the president is bound to give his assent. So constitutional scheme in Article 111 is very clear that this is not rejection, this is just withholding assent. There is another exercise which is a very strange kind of a veto, so-called veto powers, which are called as pocket veto. Pocket veto says that the president neither rejects it, nor accepts it, nor even sends the bill back. He merely withholds it and keeps it with himself. इसलिए इसको बोलते हैं pocket veto. अब president के assent के बिना तो law बनने वाला नहीं है. So it does not become a law. It has been utilized only way back in 1987 when Prime Minister Rajiv Gandhi and Gyani Jail Singh, president, had a fallout. And in that situation, Gyani Jail Singh exercised pocket veto and some postal service amendment bill, but never became a law. So that's kind of a strange kind of an exercise of Article 111, but it has been done once at least. There is a third veto, which is called absolute veto, which might in effect cause the rejection of the bill. But worry not, that is to be done usually only when the cabinet resigns before the bill is assented to, or on the advice of the Prime Minister. That causes rejection. So, if I am not wrong, the PEPSU bill was done or was rejected by that absolute veto. Either ways, Article 111, very important, is not to be exercised for money bills, at least in complete consideration. So, this is important. You may ask him to send it. It says very specifically not for money bills. You cannot send it back for reconsideration in case of money bills. So, Article 111 is very clear, right? And you can understand this part. Let's look at the next one. And we are in a very interesting zone now. Let's look at Article 124. We are in a very interesting zone now. We are now talking of the Supreme Court. Quickly write this down. So, establishment and constitution of the Supreme Court. So, Article 124 of the Constitution deals with Supreme Court. Now, wait. If I look at this in totality, from Article 124 to 147, Sara ka Sara constitutional articles are dealing with the Supreme Court. But I would suggest, I would dare say rather, that 124 सबसे ज़्यादा वॉल्यूमिनस है, 124 सबसे ज़्यादा एग्जाम पॉइंट ऑफ व्यू से is the most important. So what have I done? Article 124, 1, 2, 3, 4, 5, 6, up clause 7. I have summarized it and it is on the board in seconds. Okay, so first write everything and then you will be able to understand this part. So this is the original one. Okay, so don't take 7 other judges. Okay, now it is 33 more judges. This is the original constitution. So now it is 33 plus the Chief Justice of India. So make no mistake. First copy this, I would suggest, and then I would, otherwise if I come in front of the screen, you won't be able to copy it. Quickly. The Supreme Court of India consists of Chief Justice and up to 7 other judges. Don't write 7 other judges. Write 33 other judges. That's the way. As of today, there are 33 plus 1. That is the maximum sanction strength of the Supreme Court. Alright. So, keep an eye. Alright. और mark करते हुए चले जाओ. So, सबसे पहले लिखा हुआ है, what is the Supreme Court? The Supreme Court में there would be one Chief Justice of India. There will be one Chief Justice of India and 33 more judges. Alright. Now, very important. चाहे वो Chief Justice of India हो, चाहे other judges हो. Right. All of them are appointed by the President. Now, इसमें फिर से changes है. ये जो लिखा हुआ है National Judicial Appointments Commission Recommendation. Please इसको mark करो. This has been nullified rather than it has been struck down. नेशनल जुडिशल, तो मैं तुम्हारे लिए पूरा का पूरा कर रहा हूं, तो मैं एक ये टेबल हो गया ना, एक ये बॉक्स हो गया ना, यू विल बी डन विद नेशनल जुडिशियल अपॉइंटमेंट्स कमीशन एनजेएसी 99th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 2014 से डाला गया. कीप राइटिंग. 99th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 2014 एंड द रिलेटेड एनजेएसी एक्ट को सुप्रीम कोर्ट ने इन 2014 स्ट्राइक डाउन कर दिया था, नल एंड वॉइड कर दिया था. सो ये भी अब नहीं है. राइट. सो 33 अदर जजेस वाला पार्ट लिख लिया. उसके बाद तुमने लिख लिया दैट एनजेएसी वाला अमेंडमेंट एज वेल एज एनजेएसी वाला लॉ हैज बीन स्ट्रक डाउन बाय द सुप्रीम कोर्ट एंड इट इज नल एंड वॉइड. फिर लिखा हुआ है द जजेस सर्व अंटिल द एज ऑफ 65. यस, तो दिस इज द मैक्सिमम एज, कीवर्ड, the maximum age up to which the Supreme Court judges, including the Chief Justice of India, worry not on this, will serve is 65 years of age. Now, this is also something that one must note. कि ये जो 65 years of age है, this is a date determined or the age is determined by the Parliament, by law. ये बदला जा सकता है. As of today, it is 65 years of age. Very interesting question that may emerge from this is what is the minimum age that the judge needs to be appointed. Please remember and please mark this, that there is no minimum age required to become a judge of the Supreme Court. So maximum age is provided, the minimum age is not provided. ये सब आर्टिकल 124 में, if you pay close attention, to qualify candidate must be Indian citizens with either 5 years as High Court judge or 10 years as a High Court advocate or be a distinguished jurist. So agar somebody is to be appointed, the judge has to be appointed as the judge of the Supreme Court, he has to be a citizen of India. There is no minimum age provided, but either of 3 qualifications होनी जरूरी है. Number 1, या तो he should be 5 years a High Court judge or of 1 High Court or 2 or more High Courts in succession. Let me explain. So if there is a judge who is a judge of a High Court, say Delhi High Court for 5 years, qualified, or he's a judge of Delhi High Court for 3 years and judge of Allahabad High Court or rather koi bhi High Court for 2 years. So 3 plus 2 is 3 plus 2 is 5. So he is qualified. This is qualification number 1. Second, he should or he could be an advocate practicing in a High Court for 10 years or more, either 1 High Court or 2 or more High Courts in succession. And very interestingly, he could be a distinguished jurist. Word is distinguished jurist. In the opinion of the president, ये एक distinguished jurist होने चाहिए. ये लॉ की दुनिया में, लॉ के रिलेटेड नॉलेज में ये बहुत डिस्टिंग्विश, बड़ा इंटेलिजेंट होने चाहिए, बड़े शार्प होने चाहिए, उनकी कॉन्ट्रीब्यूशंस होनी चाहिए, वो ऑथर हो सकते हैं, वो प्रोफेसर हो सकते हैं, कुड बी एनीथिंग. सो दीज आर 3 क्वालिफिकेशन. कहीं पर भी मिनिमम नहीं लिखा है. अनदर इंपॉर्टेंट पार्ट जो आर्टिकल 124 सब क्लॉज 5 में लिखा हुआ है, दैट हाउ डू यू रिमूव अ प्रेसिडेंट. नाउ रिमेंबर लास्ट टाइम मैंने तुम्हें बोला था, इनफैक्ट टुडेस क्वेश्चन ऑल्सो was there that president is the only office who is technically impeached. Article 61 में लिखा हुआ है that the president is impeached. Now pay close attention. The word here is removal. The judges are not impeached. लेकिन many a times तुम्हें newspapers में दिखाई देगा XYZ judge, there is an impeachment motion against him. Now this is bound to arise or bound to give rise to confusions, but you have to understand where is this coming from. Impeachment का जो process है that India adopted, we have adopted it from the Constitution of USA. So if you look at Constitution of USA, उसमें many high offices, including the president, the vice president, many civil offices को impeach किया जाता है. Impeachment वहां पर किया जाता है, एक तो different grounds पे किया जाता है, प्लस वहां पे judges को भी impeach करते हैं. इंडिया में टेक्निकली स्पीकिंग आर्टिकल 61 को छोड़ के कहीं पर भी इंपीचमेंट वर्ड नहीं लिखा हुआ. तो टेक्निकली द ओनली वन हु इज इम्पीच्ड इज प्रेसिडेंट. लेकिन सिंस वी अडॉप्टेड दिस एंटायर कॉन्सेप्ट फ्रॉम कॉन्स्टिट्यूशन ऑफ यूएसए, इन सम वे देयर हैज बीन एन ओवरलैप ऑफ लॉजिक एंड वी हैव डिराइव्ड दैट लॉजिक एंड वी हैव ड्रॉन अ पैरेलल फ्रॉम यूएसए एंड टू इंडिया. और हम लोगों ने लिखना स्टार्ट कर दिया कि जजेस आर इम्पीच्ड बिकॉज दिस इज ऑल्सो वन ऑफ द हाई ऑफिसेस. अब ये डिपेंड करता है कि तुम्हें एग्जाम में क्वेश्चन कैसे पूछा जाए. अगर एज अ मैटर ऑफ फैक्टली तुम लोगों को मेंशन करना है तो प्लीज बी वेरी वेरी क्लियर ऑन दिस पार्ट. को टेंशन ही मत लेना. ओके, क्लियरली मेंशन कर देना कि हाँ इट इज ओके, इंपीचमेंट एंड रिमूवल वन एंड द सेम. बट इफ द एग्जामिनर इंटेंड्स टू आस्क यू कि इंपीचमेंट है कि रिमूवल है, बी वेरी केयरफुल and answer technically speaking president is the only one who is impeached and nobody else is impeached. एक लास्ट लाइन का पॉइंट इज वेरी इंपॉर्टेंट. ओके, सो हु इज अपॉइंटिंग द जज ऑफ द सुप्रीम कोर्ट? इट इज द प्रेसिडेंट. हु इज गिविंग एडमिनिस्ट्रिंग ओथ? द प्रेसिडेंट, एंड सो ऑन एंड सो फोर्थ. नाउ चीफ जस्टिस, राइट? नाउ द लास्ट पार्ट इज he cannot practice law after their term. Now here is a very important thing. Independence of judiciary is a crucial element behind the entire concept of rule of law. Rule of law चल ही नहीं सकता if there is no independence of judiciary. Correct? So constitution scheme is so beautifully and intricately related to that we ensure that neither my judge is under fear and nor under greed or favor by this executive. In the sense, कि हम इंश्योर करते हैं कि प्रेसिडेंट साहब अपॉइंट कर रहे हैं, तो हाईएस्ट ऑफिस इज अपॉइंटिंग यू। आगे जब जाके देखेंगे तो हम ये देखेंगे इवन द सैलरीज, अलाउंसेस एंड पेंशंस ऑफ द सुप्रीम कोर्ट जजेस, दे कैन नॉट बी वेरीड टू द डिसएडवांटेज। कम नहीं किए जा सकते वंस दे अज्यूम ऑफिस, बढ़ाए जा सकते, कम नहीं किए जा सकते, एंड देन देयर आर मेनी अदर्स, राइट। हाउएवर, अब मुझे यह भी देखना है कि while he is the sitting judge, right, he is sitting judge in the highest court of India, तो एक बहुत अच्छी कंडीशन डाली जाती है that once the Supreme Court judge retires, he leaves office, he cannot practice law in any court of India. No, as an advocate, he cannot plead before any court of India. Now, this is also to ensure that there is no fear के साथ साथ no favor. Beautiful. So, मैंने आर्टिकल 124 को, राइट, ऑल 1 2 3 4 5 6 7 को मैंने समराइज करके वन पैराग्राफ बनाया। ऑल यू रिमेंबर इज ये 7 नहीं है, ये 33 है, ये जो पुराना है वो उसको मैंने हटा नहीं सकता था, और एनजेएसी नल एंड वॉइड हो चुका है। लेट्स लुक एट द नेक्स्ट वन। द नेक्स्ट इज आर्टिकल 129 ऑफ द कॉन्स्टिट्यूशन। फर्स्ट राइट दिस डाउन, the Supreme Court to be a court of record. Right. The Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for the contempt of itself. पहले लिख लो. That's one of the problems which aspirants don't do. First, you have to write in the exact technical words as is given, और उसके बाद simplify करना होता है. So in the process of simplification, don't miss the details. So first word here is court of record. Court of record is a very interesting term. So whether you look at Supreme Court or High Court, both of these constitutional courts are called as courts of record. Now, court of record matlab whatever proceedings are happening in the Supreme Court and the High Court, of course, जो भी proceedings हो रही है उनको record किया जाता है for perpetuity. मनेका गांधी वर्सेस यूनियन ऑफ इंडिया 1978 का केस था, केशवानंद भारती 1973 का केस था, शंकरी प्रसाद 1951 का केस था, गोरखनाथ 67 का केस था, श्रेया सिंघल 2014 का केस था। वरी नॉट, वो चला गया थोड़ा ना, वो गुजरा हुआ वक्त जो है कि लौट के ना आ सके, ऐसा वाला सिचुएशन नहीं है। एवरी पॉसिबल थिंग or related qua that proceedings is recorded. It is a part of perpetual record and can be utilized as evidentiary value. So Supreme Court and the High Courts both are courts of record. ये याद रखना. Now pay attention to the subsequent lines here. It says it shall have all the powers of such a court, including the power to punish for contempt of itself. अदालत की अवमानना, the word that is utilized very often, is the word which is contempt of court. Today, in the class, in the earlier part of the class, earlier in the day, we did Article 105 of the Constitution. Remember? That was dealing with parliamentary privileges. Now, parliamentary privileges also advise, right, also suggest कि अगर तुमने पार्लियामेंट का कोई ऑर्डर नहीं माना, पार्लियामेंट ने बोला we don't want XYZ to be published, we don't want XYZ to be shown on TV, and somebody decides to go against the order of the parliament, parliament can hold him or that entity guilty of what is called as contempt of house. कि आपने सदन की अवमानना करी है. Drawing a parallel from सदन की अवमानना, we can also have अदालत की अवमानना. Drawing a parallel from contempt of house, you can also have contempt of court. Now, would there be a difference? Yes, there is a huge difference. And that difference is in 129, जो contempt powers of the court है, इसको कोडिफाई किया गया है. इन अदर वर्ड्स, इससे रिलेटेड एक लॉ बनाया गया है, एज अपोज टू पार्लियामेंट जिसमें देयर इज नो लॉ, प्रैक्टिकली इनफाइनाइट, इनडेफिनेट नंबर, अनलिमिटेड नंबर ऑफ पार्लियामेंट्री प्रिविलेजेस किया जा सकता है. यहां पर ऐसा नहीं है. They will have to, I mean the court will have to take whatever punishment, whatever is to be required. Is it contempt or not? What are the different types of contempt? It's all written in one law जिसको बोला जाता है the Contempt of Court Act of 1971. जिस Contempt of Court Act 1971 में दो तरह के contempt डिस्क्राइब किए गए. एक is civil contempt, the other one is criminal contempt. सिविल कंटेम्प्ट इज विलफुल डिसोबीडियंस ऑफ द ऑर्डर ऑफ द कोर्ट. कोर्ट ने बोला ये करो, तुमने नहीं किया जानबूझ के. कोर्ट ने बोला ये मत करो, तुमने फिर भी किया जानबूझ के. दिस वुड बी हेल्ड एज सिविल कंटेम्प्ट. Then there is a criminal contempt also. Criminal contempt is you scandalize, you prejudice, you interfere, you obstruct with the flow of justice. You bring disrepute or you reduce the reputation of the judiciary. तुमने judicial system पर बिना बात पे, बिना किसी substance के, just for disregard उनको करने के लिए, insult करने के लिए, to bring them reputation down, तुमने इल्जाम लगाना स्टार्ट किया. यू आर ऑब्स्ट्रक्टिंग द फ्लो ऑफ जस्टिस. ये सब कैन बी कंस्ट्रूड एज क्रिमिनल कंटेम्प्ट. These are two different types of contempt written in Contempt of Court Act of 1971. Make sure that you don't make a mistake. वो यहां नहीं दिया हुआ है. It's not written in 129. 129 में सिर्फ ये लिखा हुआ है that they can have the power to punish for the contempt of itself. What are the different types of contempt? ये लिखा हुआ है Contempt of Court Act of 1971 में. So make sure ये क्वेश्चंस आते हैं. And if I'm not wrong, ये थोड़े साल पहले इस तरह का क्वेश्चन आया भी हुआ है, right? But most of you would not even appreciate कि ये कहां से आ गया. It has come directly from the Constitution. तो ये जो बेयर एक्ट वाला वीडियो है ना, ये तुम्हारे लिए बहुत फायदेमंद होने वाला है, बशर्ते कि तुम इसको रिवाइज कर लो. तो लेट्स लुक एट नेक्स्ट वन. Article 136 of the Constitution. First, write this down. Special leave to appeal by the Supreme Court. पहले लिख लो. Special leave to appeal, popularly called as SLP. All right. So, first things first. The word here is leave. Okay. Now, what is this leave? Now, leave जो normal English में use करते हैं, that is not this leave. This leave is permission, इजाजत. Okay. Now, let's get back to the structure. So, imagine, picture this, okay? So, imagine that there is a pyramid, right? So, जो pyramid है, it's like this, right? Pyramid जो है, उसमें wide base है, then you narrow it down into an apex. The highest court of that pyramid is the Supreme Court of India. Supreme Court is also described, and that is why, in so many words, is described as the highest appellate court of India. Okay, highest appellate court. All the appeals, right from the bottom, कोई भी lowest most court से लेकर, will or can reach the Supreme Court. Now, just picture this. Get the larger picture on this part. Okay. Imagine कि Supreme Court में कितने judges थे? We just did this 124. The maximum number of judges that can be in the Supreme Court is 1 plus 33. 34 judges. Chief Justice of India, 33 more judges. Most of them are arranged into the groups of 2 or 3, benches of 2 or 3. So practically, it's a very small court. What did I say? I said there is a pyramid. जितने भी लोएस्ट वाले कोर्ट्स है, सारे के सारे केसेस कैन पोटेंशियली रीच द सुप्रीम कोर्ट. इमेजिन कि आप एक शहर में रह रहे हो, जिस शहर में जितनी भी रोड्स है, ऑल द रोड्स फाइनली कैन कन्वर्ज इनटू वन चौराहा और वन पार्ट ऑफ द शहर. डू यू रियलाइज कि ट्रैफिक जैम बड़ा नॉर्मल होगा उस एरिया में, और भयंकर ट्रैफिक जैम हो जाएगा. तो मच सो कि वहां से कुछ मूवमेंट ही पॉसिबल नहीं होगी. राइट नाउ, हाउ डू यू प्रोटेक्ट दिस? हाउ डू यू प्रोटेक्ट और हाउ डू यू इंश्योर दैट द व्हील्स ऑफ जस्टिस कीप मूविंग? वन ऑफ द मेथड्स इज 136. 136 इज स्पेशल लीव टू अपील. इट सेज कि not all matters will reach the Supreme Court. No, all matters can reach the Supreme Court, but not all matters will be heard by the Supreme Court unless the Supreme Court gives you leave, permission, इजाजत. That is only possible अगर तुम Supreme Court को satisfy कर दो that, for example, there is a substantial question of law, या फिर my lord, दिस इज रिक्वायरमेंट. ये जो कोर्ट जो केस मैं आपके पास लेकर आ रहा हूं, द वन विच आई एम गोइंग टू आर्ग्यू बिफोर यू, दिस इज डीलिंग विद कॉन्स्टिट्यूशनल इंटरप्रिटेशन, समथिंग ऑन दोस लाइन्स. Till such time that we are able to convince the Supreme Court, we are able to satisfy the courts that, my lord, XYZ matter, the appeal that I am bringing to you from XYZ matter, which is an impugned order, it is dealing with substantial question of law, substantial interpretation of Constitution of India. Till such time, Supreme Court won't hear your matter. So, सबसे पहले, before you reach the Supreme Court or before your matter is heard, you have to first pass through a trial, or rather trial by fire rather, which is called as SLP, Special Leave Petition. Special Leave Petition is filed under Article 136 of the Constitution. Imagine, ये इसको एक screening exam की तरह समझ लो. Before you pass the screening exam, you cannot, unless and until you pass the screening exam, तुम mains में नहीं जा सकते. It's very similar to your prelims and mains, right? In the same way, first you have to pass through SLP. Once you are satisfying the court that SLP is admitted, only then the next stage will happen. That is 136 of the Constitution. Next is Article 142 of the Constitution. Enforcement and decrees and orders of the Supreme Court and orders as to discovery, etc. The Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as is necessary for doing complete justice in any case or matter pending before it. As I've told you, first write this down. जब तक तुम ये लिखोगे नहीं, you will not understand, you will not appreciate this part. I don't know whether it caught your attention or not, but there's one beautiful word here, something that you must notice. The word here is complete justice. This is the key word. This is the operative word of this article. So what does Article 142 says? Article 142 gives extraordinary powers to the Supreme Court. Supreme Court says that in any matter pending before it, it can pass any order, it can pass any decree which is necessary for doing complete justice. Now, one may ask, one may wonder, yeah, justice to समझ में आता है. What is complete justice? And this is an interesting part, right? कि justice तो we got it, न्याय. ये complete justice क्या होता है? Right. So you'll have to understand this part. Let me give you an example. And first, to illustrate my point, let me show you something. So let's go back to Ayodhya case judgment. So, you know, the Babri case judgment, the Rama Janmabhoomi case. So essentially, Rama Janmabhoomi case was a land issue. वो जमीन, the विवादित जमीन, was being claimed by two communities. One said this is ours, the other one said this is ours, right? Essentially, it boils down to ये जमीन किसका है? That's it, right? Now, pay close attention. Now, the judgment came. The Rama Janmabhoomi case judgment came. The Supreme Court said in its judgment that in our understanding, okay, we hold that this zameen, this piece of land belongs to A. Correct. Finished. Wait. Supreme Court further said that B community should also be given an alternate piece of land. उनको भी एक alternate piece of land मिलना चाहिए. Now, one may argue or one may ask, ये तो मुद्दा ही नहीं था. It was a plain simple land issue. Does it belong to A? Does it belong to B? You've decided it belongs to A. ये alternate वाला तो prayer में भी नहीं था. You know, this was not something that we were contesting. What would Supreme Court say? Supreme Court would say, in delivering or in providing for an alternate piece of land to the other community, we are doing complete justice. Complete justice, right? And this is what Article 142 provides. So, Ayodhya judgment was an awesome example of Article 142. Similarly, very recently, not too back in time, Perarivalan, the one of the accused in Rajiv Gandhi assassination case, जिनका कि मर्सी पिटिशन डिले पे डिले हुए जा रहा था, वो जो मर्सी पिटिशन डिले पे डिले हो रहा था, सुप्रीम कोर्ट सेड दिस इज फनी बिजनेस, राइट? वी विल नॉट सी अ मैन सफर जस्ट बिकॉज तुम्हारा ये डिले ही नहीं खत्म हो रहा. वरी नॉट. दे पास्ड एन ऑर्डर, फ्री दिस मैन. पेरारीवलन को फ्री कर दिया गया यूजिंग विच पावर्स? 142. These are extraordinary powers provided to the Supreme Court, and in this they can pass practically any order. Now this is kind of surprising because rule of law country में democracy में unlimited powers बहुत कम होती है, right? But Supreme Court has it, and what is interesting is कि 142 cannot be limited by a parliamentary or statutory law also. This is a very immense part. So I hope it's a very interesting part. Read about 142 और एक बार Google पे जाके 142 के examples है ना, you'll see this in Bhopal gas tragedy case, you'll see this in Perarivalan case, you'll see this in Ayodhya and many other. So you're really going to be very happy knowing कि Supreme Court, and that is why 2015 में एक question आया था, Supreme Court is the custodian of the Constitution of India. Question is what, which among the following is the custodian of the Constitution? That is the Supreme Court. So quickly let's go to the next one, and this is simple, but I just wanted this to be brought to you. Notice, so इसमें कुछ explanation तो नहीं था, लेकिन I just thought you should know 148. So 148 deals with Comptroller and Auditor General of India, popularly called as the CAG of India. This is an interesting thing. You know who's the CAG? CAG is either an IAS officer who's appointed by the President of India as the CAG, or sometimes an IAAS officer, Audit and Account Services officer. But I'll tell you something. 148, this is very interesting, 148, 149, 150 and 151, 4 articles of the Constitution. 148, 149, 150 and 151 deals with one office, that is the CAG. Just to get the perspective, let's look at Article 74. Article 74 says there shall be a Union Council of Ministers to be headed by the Prime Minister. 75 talks about collective responsibility. 76 takes you to Attorney General. So, in other words, I'm very surprised, right, that there are only 2 articles pertaining to Union Council of Ministers and Prime Minister, but 4 articles dedicated to one office, that is the CAG. That actually, not in the truest sense, but actually it does give you a hint which actually proves the point that Baba Saheb, Dr. B.R. Ambedkar, during the Constituent Assembly debates, spoke a very beautiful line in praise of the CAG of India. And in so many words, I'm just paraphrasing, he said, this is going to be the most important office in India. Most important dignitary of India, dignitary office of India. In other words, एक ऐसा constitutional office जो कि elect भी नहीं हुआ है, neither directly nor indirectly. He is an IAS officer or an IAS officer who is appointed by the president as the CAG of India. उनको most important, this is an asked question by the way, right? So CAG of India is the most important. 148 to 151 is CAG. इसको ऐसा क्यों रखा गया होगा? Why would there has to be some kind of underlying logic behind it? So going by the logic, do you realize कि Lok Sabha and the Rajya Sabha, the Parliament, once they pass the budget, the money of the people of India को regulate करना है, उसको appropriate करना है, that is the job of the Parliament. Executive यानी government को वो पैसा मिलता है towards a particular policy, towards a particular aim, obviously welfare of the people. So if you read recently, अगर तुम newspaper read कर रहे हो, तो open today's or probably yesterday's newspaper, probably आज का भी newspaper में होगा. So the CAG of India has pointed out कि Delhi में, okay, there has been a misappropriation of funds. वो ठीक से नहीं हुआ है, पैसा खर्चा नहीं हुआ है. फिर थोड़े टाइम पहले आया था उत्तराखंड में जो पैसा लगा था फॉर फॉरेस्ट कंजर्वेशन, वो ठीक से नहीं यूटिलाइज हुआ है. डू यू रियलाइज इन अ वे CAG is acting on behalf of the people of India to keep a check on the government कि जो तुम पैसा खर्चा कर रहे हो ना उसको ठीक से करना, रीजनेबल वे में करना, लीगल वे में करना, कॉन्स्टिट्यूशनल वे में करना. वी आर कीपिंग एन आई. So this is a very important concept of keeping checks and balances on the basis of finance. Hence, CAG is a very important office. So look at, मैंने तुम्हारे लिए एक छोटा सा शॉर्ट नोट बना लिया है ताकि तुम लोग को याद हो जाए. CAG is appointed by the president, can only be removed like a Supreme Court judge. जैसे एक सुप्रीम कोर्ट जज को रिमूव करते हैं वैसे ही इन द मैनर लाइकवाइज कैग को रिमूव किया जा सकता है. आई होप यू अंडरस्टैंडिंग, ब्रिंगिंग हिम टू द सेम पोजीशन एज अ सुप्रीम कोर्ट जज इन सो फार एज removal is concerned. Before taking office, they must take an oath before the president. This is all the same. Their salary and service conditions are determined by the parliament. This is also the same as judge of the Supreme Court. You cannot change or you cannot reduce his salary, allowances and pension post appointment. Unbelievable. This is also the same. They cannot hold further office after their term. Almost on the same lines, you can draw a parallel in the sense that the judge of the Supreme Court cannot practice law in any court of India after he is retired. Indian Audit and Accounts Departments are set by the rules made by the President in consultation with the CAG. Administrative expenses for this office are charged to the Consolidated Fund of India. So, if your expenses or your salary is charged directly to the Consolidated Fund of India, it is a non-votable expenditure, popularly called as charge expenditure. Surprisingly, interestingly, it is the same as the judge of the Supreme Court. How interesting. CAG and the judge of the Supreme Court practically on the same grounds. In fact, it is not a coincidence that in दोनों offices का oath इस मामले में भी अलग है. It is distinctive from all others in the sense that ये दोनों ही अपने oath में बोलते हैं that I will bear true faith and allegiance to the Constitution of India. मैं संविधान के प्रति सच्ची श्रद्धा और निष्ठा रखूंगा. But the last line, both of them say, and this is the only two officers which subscribe to this oath, and they say that we will uphold the Constitution and the laws. Amazing. Which automatically brings them to a very different kind of a footing, a different type of light as compared to rest of the officers. So I'll just give you 30 seconds. Either you take a screenshot of this, you take a pic of this, or you might as well want to write it. I'll be more than happy to allow you to write this down. Alright. तो इसको pause कर देना वीडियो को. Alright. And इसको लिख लो. This will help you remember things. Okay. अगर तुमको technical words नहीं भी आते तो. Let's look at the next article. Next article is 153 of the Constitution of India. So, governors of the state. There shall be a governor for each state, provided that nothing in this article shall prevent the appointment of the same person as the governor for two or more states. पहले ये लिख लो. It will do you a world of good to write it down. सबसे important word, always keep an eye. Whenever you're reading the Constitution, always keep an eye on these words. ये shall है कि may है. This is shall. So, हर स्टेट का एक गवर्नर होना कंपल्सरी है. गवर्नर एक्ट्स एज द कॉन्स्टिट्यूशनल हेड ऑफ द स्टेट. ही इज द डी जोरे हेड ऑफ द स्टेट. ही इज द टॉप एग्जीक्यूटिव, नॉमिनल हेड ऑफ द स्टेट है. तो जस्ट टू इंश्योर, आई मीन it's not exact parallel, but let's try and have some kind of compare and contrast exercise with union and the state. Union में there is the president. State में, as I said, not exact parallel, but there will be a governor. यूनियन में there will be a prime minister heading the union council of minister, and यहाँ पर there will be a state council of minister headed by the chief minister. Prime minister in the union council of minister real head executives होते हैं. State council of ministers headed by the chief minister are real executives. However, there's one difference, and that's a huge difference. The president is an elected representative. उनको indirectly elect किया गया है by the electoral college. Governor neither directly nor indirectly elect होते. He is appointed by the president. So यहां पर थोड़ा सा there is a cross connection, because the constitutional head of the state is actually appointed by the union. That makes him a debatable office, because many a times one may argue that this is an agent of the union, or rather this is one of the mechanisms how union tries to control the state. That actually draws from India is a quasi-federal state with a unitary tilt. Now pay close attention to the proviso here, provided that nothing in this article. तो ऐसा नहीं है कि एक स्टेट के हर स्टेट का गवर्नर जरूर होंगे, but there can be one governor for more than one state also, or there could be one governor for one state and an adjoining union territory also. This proviso was added to Article 153 by the 7th Constitutional Amendment Act of 1956. तो यहां पर याद रखना, एडिशनल चार्जेस मिल सकते हैं टू द गवर्नर अंडर आर्टिकल 153. नथिंग इज स्टॉपिंग. सो इट सेज वेरी क्लियरली, लिखा क्या है, नथिंग इन दिस आर्टिकल शैल प्रिवेंट द अपॉइंटमेंट ऑफ द सेम पर्सन एज अ गवर्नर फॉर 2 और मोर स्टेट्स. तो 2 या 2 से ज्यादा स्टेट्स में, या फिर उसके साथ एडजेसेंट यूनियन टेरिटरी में, you can have a governor. So I hope you can understand this one. So Article 153 is clear. Now it is easy now, right? अब सब कुछ बहुत सारे easy हो जाएंगे. You can continue utilizing rule of 89. मैंने क्या बोला था? I think I've repeated this 5 times today minimum. Article 79 says there shall be a Parliament, and the Parliament will consist of the Lok Sabha, the Rajya Sabha, and the President of India. Add 89, you will arrive at a number called 168. Exact parallel. For every state there shall be a legislature which shall consist of a governor. तो president की जगह governor. वहां पर लिखा है लोक सभा एंड राज्य सभा. In other words, at the level of the union, लोक सभा and राज्य सभा होना mandatory है. You have to have 2 houses. यहां पर नेसेसरीली नहीं है. इन अ बंच ऑफ हाउस स्टेट्स देयर आर 2 हाउसेस. इन अदर स्टेट्स देयर इज 1 हाउस. जहां पर 1 हाउस होगा, दैट 1 हाउस विल बी कॉल्ड एज लेजिस्लेटिव असेंबली, ऑल्सो कॉल्ड एज विधानसभा. जहां पर 2 हाउसेस होंगे उसको बोला जाएगा विधानसभा एंड विधान परिषद. तो नॉट ऑल द हाउसेस, नॉट ऑल द स्टेट्स चोज टू हैव 2 हाउसेस. कब बंच ऑफ स्टेट्स हैड? सो महाराष्ट्र, कर्नाटका, आंध्र प्रदेश, तेलंगाना, उत्तर प्रदेश एंड बिहार. They decided to have bicameral structure. Baki decided to have unicameral structure. I hope you can now easily draw a parallel. Let's look at 191. Arey, this is interesting. So today in the class, earlier in the day, we did 102 of the Constitution. 102. In fact, that was the first article that we discussed today. 102 deals with, you want to write this, you are free to write. 191 deals with, 102 deals with the disqualifications of the members of Parliament. It will be a wonderful experience for you if, without opening your notes, or if you are making notes in the first place, if without opening your notes, you would be able to remember what are the grounds for disqualification. बड़ा मजा आएगा. Okay, so I hope you try that, but just in case you don't know. So they are office of profit. If you're occupying an office of profit under the government of India or the union government or the state government. Number 2, that you are declared as of unsound mind by an incompetent or by a competent court. You are an undischarged insolvent. You decide to change your citizenship to another foreign country. You acquire another foreign country citizenship, or you are disqualified by under or any law made by the Parliament. Usually Representation of People's Act of 1951. ये हो गया 102 1 A B C D E, and then you have 102 subclause 2, which says that you may be disqualified under 10th schedule, that is anti-defection law. उसी को पूरा का पूरा 102 add 89, you will arrive at 191. Exactly same copy paste. You will find disqualifications for members of state legislature. Exactly. Don't change a word. सिर्फ वहां पे पार्लियामेंट को हटाकर स्टेट लेजिस्लेचर लिख देना, 102 को हटा के 191 कर देना. योर जॉब इज डन. सिंपल. एंड इफ योर जॉब इज डन, सो जस्ट हैव अ लुक एट दिस. मैंने एग्जैक्टली यहां पे लिखा हुआ है A person is disqualified from being a member of the Legislative Assembly or Council if they hold an office of profit under the Government of India or any specified state, declared unsound mind by a competent court, undischarged insolvent, no longer a citizen of India or acquired foreign citizenship, or disqualified under any law made by the Parliament, or last wala is office of profit. Now you understand, this is the context of understanding this part. सबको समझना है. So 10 schedule का ये काम हो गया and you can understand. Last, which will bring a smile to your face, फिर से rule of 89. 111, which was dealing with, जो आज हमने किया था, the president, once the bill is passed by the parliament, ये भी तुम लिख सकते हो, you can just write the heading. Heading लिखोगे तुम्हें याद हो जाएगा. Once the bill is passed by the two houses of the parliament, it shall be presented to the president. The president shall either give assent to the bill or withhold his assent therefrom. Exactly 89 add कर लो, right? So you will arrive at Article 200 of the Constitution of India. Article 200 of the Constitution, same cheese, exactly same. Once the bill has been passed by either one house, depending upon कि वो unicameral structure है, that is the Vidhan Sabha, or both the houses of the state legislature, it shall be presented to the governor. The governor will either give his assent or withhold his assent therefrom. Exactly same. इसमें सिर्फ एक part अलग है. In certain cases, कुछ bills में, if in the opinion of the governor, जो bill pass किया गया है, it is against the Constitution of India, it is against directive principles of state policy, it is against union powers or it is undermining union powers, it is against national interest or people's interest, or it undermines the powers of the High Court of the state. 5 ऐसी conditions. So, governor can choose to send this bill for the reconsideration of the president. Picture this, state का bill जा रहा है union में for the reconsideration of the president. Again proving our point that India is a quasi-federal state with a unitary territory. There are many proofs with relationship to this. Either ways, that is Article 200 of the. If you pay close attention, when a bill is passed by state's legislative assembly or both the houses, it is presented to the governor who can either assent, withhold assent, or reserve it for the president's consideration. The governor may return non-money bills. Please remember, again, like everything else, it is not associated with money bills. I hope you have understood and enjoyed this. So, part 2 is concluded here. मैंने article 101 से लेकर 200 को second part माना है, and a bunch of these articles are very important. Some of them directly related to one another. Some of them can be understood together. Some of them can be understood only separately. इनको पढ़ लेना, ध्यान से लिख लेना, और if you are able to remember them, trust me, you will become a far better polity student than through any other source. I hope you have enjoyed this. Watch out for session number 3. Till that time, make sure that you revise this. I'll be very happy to teach you following. The words of an academy, let's crack it. Until next time, God bless, thank you, and Jai Hind.